Okay, we're live. Mr. Beck, if you could announce the name and cause number of this motion.
Yes, sir. Cause number DC-19-16772. Case name is Mariluz Macias versus CW Young Construction and Cipriano S. Hernandez.
Okay, and you represent the plaintiff?
Yes, Your Honor.
And Mr. Wright, if you want to announce your name and who you represent.
Thank you, Your Honor. Your Honor, Todd Wright for defendant CW Young Construction and Cipriano Hernandez.
For those of you who've been watching the YouTube channel today, this is another motion to strike counter affidavits. This is the third one we've had today, so on 3 different cases. So it's been very popular issue today. Mr. Beck, I read your motion. I read the response. It looks like we have 7 counter affidavits this time. Is that right, or 8? I don't know if I counted it correctly.
So for plaintiff's motion to strike counter affidavits by Gregory Money, I believe there are 4.
Okay.
I believe you have exhibits A through D. And that's where I wanted to begin,
Okay.
Your Honor, with that one. We can do this one first and then the other motion, which is pretty much the same type of arguments, except for, in regards to plaintiff's motion to strike the counter affidavits of Gregory Money, we have put in plaintiff's motion the argument that Mr. Money is not qualified. I do want to back up and, I'm not going to go through and, given that this is the 3rd hearing you've had on this today and no telling how many you've had in the past, all I want to do as far as with regards to the law is just to remind the court that, which is probably well aware, that, the intent of 18.001 is to allow plaintiffs to save time and money in order to prove up their medical bills, and instead of having to hire an expert and depose their treating physician and be able to prove up their medical bills this way. Here is a situation where all of plaintiffs.
So let me just. I appreciate that. I don't mean to cut you off. I see these all the time, and I'm very familiar with this area. So what I try to be, and I think my interns could probably just tell you. So what do I do, Ms. Favela? You saw the hearing this morning. If someone is a billing clerk, what do I always do? See if you can remember from this morning.
In terms of the counter affidavit?
Yeah. Do I strike the counter affidavit or not if it's a billing clerk?
Usually you like to have it from a medical doctor.
Right. So what do I do?
You strike from the billing.
Every case I strike the billing record affidavit for if it's a billing clerk, if it's someone who's not a doctor or medical professional. So I will strike Mr. Money's, and it's no offense to you, Mr. Wright. I do this in every case. The attorney this morning got a little upset about that, but that's how I do it in every case until I'm told by the Supreme Court of Dallas Court of Appeals I need to do something different. So, the Mr. Money is struck as not as an expert, but his counter affidavit is struck. It's significantly more difficult to analysis for me with the other ones, and so let's kind of move to those.
Your Honor, before we move on, can I just say one sentence about Mr. Money?
Sure.
Mr. Money is not offering any opinions, contrary to what's represented in the motion, on the necessity of any medical treatment. It's solely focused on the reasonableness of the associated charges.
Thank you for sharing that. I appreciate that. But that doesn't change my analysis under paternity peril. And I'll just say to you, Mr. Wright, this is how I deal with every single time this comes up. I probably had this come up over 30 times since this started happening. We didn't used to ever see this before, where you had billing clerks who would try to file counter affidavits. It's kind of a new thing. I guess it's that Tyler Court of Appeals decision is causing attorneys to do that. But I strike them every single time. So, you can obviously appeal me, and or if there's a Dallas Court of Appeals decision or Supreme Court decision that says to the contrary, but I strike them every time. It has to be a medical provider of the same area of specialty that they're controverting for me to consider them. So I just, I have most attorneys. I had an attorney this morning who had a number of hearings in front of me, and she had kind of listened to what I said, and she got the exact right type of expert and exact right kind of contrary affidavit. And she actually, I did not strike the counter affidavit. I've had another attorney who has filed billing clerk affidavits 10 times in my court, and every time I've struck them, and he keeps spending money on it. And I'm not, maybe he's just trying to make an appellate record or something. I'm not sure why, but I just want to let you know that's my position on every single case. I want to make it as easy as possible for you going forward to know what my position is.
And Your Honor, I appreciate the education, and I appreciate you indulging me in that regard. Thank you.
Oh, no problem. Let's talk about the medical counter affidavits.
Okay. So that's plaintiff's other motion to strike, titled Plaintiff's Motion to Strike Defendant's Expert Doctors Counter Affidavits. And plaintiff has attached as exhibits A through L 12 different counter affidavits filed by 7 different doctors. And essentially plaintiff's argument with respect to those counter affidavits, Your Honor, is pretty much universal, or pretty consistent across the board. It's our position that the defendant's counter affidavits don't provide reasonable notice for the basis of their opinions on the grounds, or in support of that is they're conclusory. Throughout the counter affidavits, the counter affiants give ranges of factors in order to calculate their amount of reasonable charges. And what I mean by that is they'll say, the reasonable amount is anywhere from 140 to 170% of what Medicare charges. And with all due respect, it's, to defense counsel, that's totally irrelevant. She's not a Medicare recipient. She's treating through LOP, and there's no surprise to anybody that she is. But that the Medicare rates have nothing to do with this situation.
Let me say one other thing. And this is how I deal with this in every single case is if they're relying solely on Medicare or workers' comp or health insurance reimbursement rates, that's apples and oranges. I don't allow that, and I strike that in every situation if that's the sole thing they're relying on. If they're instead also relying on an analysis of what uninsured folks pay as kind of the retail rate, and is that unreasonable compared to that, and they have knowledge of that, they can show they have knowledge of that, I will consider that as a part of a counter affidavit. So for these counter affidavits, are they all solely relying on I apologize, my dog keeps sighing in the background. I keep thinking there's someone in the room with me, so apologize about that. But if they're relying just on Medicare rates, workers' comp, health insurance reimbursement, then I do strike those. But if they're relying on an analysis of retail rates, so to speak, then I will consider those. So, Mr. Wright, which are they doing in this situation, or does it kind of depend on which doctor?
No, the medical providers are all uniform in this respect, Your Honor, in that they do not rely and say that the Medicare rate is the appropriate reasonable charge.
Okay.
They discuss the varying rate structures for those with private insurance, those who may be on a Medicare scale, those who may be on a workers' compensation scale. Those are all discussed, and each of the doctors says that, in my practice, we see this, and I have determined charges in my own practice for within that own particular discipline, and for the reasonable charges in the Dallas-Fort Worth area for those who are self-pay, such as plaintiff, is the sums stated in the particular affidavits.
Well, have you all thought about doing dueling affidavits on this?
What do you mean by that, Your Honor?
Oh, wow. Mr. Wright, are you familiar with dueling affidavits?
Yeah, I suspect you mean where the parties agree to submit both to the juror and the jurors then pick who they like best.
That's pretty much right. But so it allows the defendants to bring in the counter affidavits as evidence, but it allows the plaintiff to not have to call their doctors live. Do you usually do that, Mr. Wright, or do you ever do that?
We don't as a matter of practice, Your Honor.
Your Honor, if I may, can I point you out to the language of these counter affidavits where they're calculating the reasonable amount?
I mean, I've read them, but yeah, if you want me to point to a particular page, give me the page number.
Yes, sir. So like Exhibit A, page 5.
So if you could tell me the PDF page number would be.
Okay. If it's the PDF with 148 pages,
Yeah.
then it would be PDF page 14.
Let me see.
And it would be that first full paragraph where it says, "It has been my experience."
Yeah.
So they throw in the self-payer language at the very end, but essentially they're calculating it, with regards to Medicare. I mean, they're not going through and saying these doctors have these rates, these rate of charges, and providing rates or charges with regards to self-payers. They're just throwing in the self-payer language at the end, which is kind of misleading, if you ask me.
Your Honor, I don't believe that's a fair characterization of the sum and substance of the affidavits or the report. The doctors do talk about Medicare. They do not adopt the Medicare rate and say that is the reasonable charge. The affidavits and their accompanying reports go into great detail about how those figures are calculated and how the particular affiance then made the determination as to what they calculated the reasonable charges to be as expressed in the affidavits.
Guys, let me take a quick break. If you guys could just kind of chat about this and see if you can work out some kind of agreement as to this issue, that would be great.
Okay. Well, Mr. Wright, I think what I'm going to need to do is I'm going to step out for 1 second, make a quick phone call, because I've never done what's called a dueling affidavit. I've never even heard that.
Yeah, I haven't done one either.
Okay. Well, I'm glad I'm not the only one, because I felt like I just was not very knowledgeable about something. I never heard of that. Okay.
No, it is an interesting thought. Yeah, and likewise, let me run down the hall right quick.
Okay.
So let me say this: when I used to do plaintiff's personal injury, and we used to do them all the time, dueling affidavits, and I've done them countless times in trials in my court. So I don't know if other judges do it. I thought other judges do it as well, but it's something I've been seeing in court for close to 25 years. So this isn't some new thing that I just created on the fly. It's something that's been around for a long time.
No, and Your Honor, full disclosure, I think probably the last dozen or more cases I've been to trial on have been wrongful death and the employer's liability context, where we're not fussing over the cost of associated medical care. It's just solely the gross negligence issue. So
no worries. I just wanted Mr. Beck to know that this is not something that's new. That's something that's been around for quite some time. So
okay.
I'm not trying to give anyone a hard time. Mr. Beck, you said you need to make a phone call.
Yes, sir. I don't want to get, yeah, I need to. I don't
I don't
want
want
to
you to get in
in
trouble either. Trust me, I was in your situation many times when I was in private practice. So,
Yeah, okay.
And Your
why don't
Honor, if I may, just jumping ahead a little less than 24 hours, and to try and be respectful of the court's time and take as little of that as possible. I think we're administratively set for jury trial tomorrow.
Do you want to reset that, or what do you want to do?
Well, it's my understanding that there are no jurors available to try cases in Dallas County presently, and plaintiffs have a continuous motion on file.
I'm happy to move it. When do you want to move it to?
Plaintiffs asked for 150 days. I don't believe that much time is necessary.
I will tell you my current policy is I'm not setting anything new before June 1st. That's a jury trial. I don't think there's any way we're going to be going back to jury trial before June 1st, and that's extremely optimistic that we would be starting in June 1st. But if anytime after June 1st, I'm happy to move it to, unless you guys want to consider a remote trial. The judges are still kind of struggling with that issue about what we're going to do about remote trials. So if you guys want to talk to your clients and email me and say, hey, we'd like to do a remote trial, we could get you to trial possibly a lot quicker, but that's very much up in the air. So, but if you want a live in-person jury trial, I don't see there's any way it would be before June 1st. And probably going to be honest, what year is this case?
19.
19, yeah. I don't foresee we'll try many 19 cases this year, but I'm happy to reset anytime after June 1st. I don't think it's super realistic that it get reached.
Well, then while Mr. Beck is on the line and Judge, I'd suggest that maybe we counsel amongst ourselves as to an agreed trial date and visit amongst ourselves.
You want me to put you guys into a breakout room? Would that be helpful? And you guys could chat amongst yourself and then come back. Would that be helpful?
I think we're going to need a couple of minutes. I have run afoul before of the ladies in the office in committing to trial dates, and I am hesitant to do so ever again without consulting with them first. But Mr. Beck and I have been working well together in this case, and I think.
Are you all set for tomorrow or next week?
For tomorrow, Your Honor.
So the other option would be you'll have to come tomorrow. We'll talk about when you want to be reset. So you could either do it now or tomorrow. I have 21 cases, at least the last time I checked, set tomorrow. So you'll have to go through that whole wait. But whatever you're most comfortable with, I just was trying to help.
I appreciate you letting us know about the wait tomorrow, Your Honor. My boss, Langdon Trey Smith, he's going to be attending the hearing tomorrow, and he pretty much instructed me that he wanted to be at that one tomorrow.
Okay.
But I can call him, because I was going to call him and ask him about the dueling affidavits, and then I'll ask him about the.
Why don't I put you guys in a breakout room, Mr. Wright? You can talk to the folks in your office. You need to talk. I think you said the women in your office if that's what I wasn't sure if that was what you said, but the folks in your office that you need to talk to, and then Mr. Beck, you can call your supervisor and then just come back in, and whatever you guys want to do, we can work it out. Okay.
Excellent. Thank you, Your Honor.
Thank you. I'm going to put you in a breakout room right now.
Okay.
Okay, I think you should be getting an invitation now. Mr. Beck, you need to accept the invitation. There you go.